Morning, Your Honor. Deputy Prosecuting Attorney Rick Damerville for the state of Hawaii.
Good morning.
Good morning, Your Honor. Mike Ruggles from Mountain View Pro Se with Cody Friends Advisor.
Okay, good morning.
Morning.
Okay. So, maybe I should ask you, Mr. Ruggles, what is your position regarding representation by legal counsel?
Your Honor, I believe that I thought she was here to help. I know in the beginning, when Mr. Damerville suggested she write a motion, she did. Later, when I suggested that she write a motion, she did, but she was 2 weeks late. I personally have been going through a lot of medical problems. I've lost 4 teeth, abscess, kidney failure, and a few other things. So I've been leaning on her a little harder than I was earlier. But I've been flat on my back. I've asked her to tell me how to do subpoenas. I asked for this before the last hearing, and she said she would give me the information on how to do subpoenas, yet she never did. And so my point is that whenever Mr. Damerville emails her, she gets back within 10 minutes. When I email her, it's 2 weeks or longer. But I want to go back to the beginning, which is this. Mr. Damerville has brought it up. There's been a lot of motions going back and forth. But I can tell you this, Mr. Haspy, first off, let's go to why I never had a public defender. They said there was some kind of conflict, yet they never said what it was, but said there was a conflict. Then I ended up with Mr. Haspy, obviously a pettifogger of outstanding proportions, because he lied to me and told me that if I waived my preliminary hearing, that I wouldn't lose any rights and that it would speed up my speedy trial. Mr. Damerville said the same thing, so he lied to me as well. I waived my preliminary hearing because I'm looking out for 200 patients, sick and dying patients like me, who need medicine. I waived it. I was hoping to be in court by a month. That's why I waived it. Now Mr. Damerville's using my waiver as a reason to come after me, or that I've somehow waived some rights. My point is, if Ms. Cody isn't here to help me, then why is she here? Just to make it appear that I have help? Because I can tell you this, it's been over 10 months. Mr. Haspy told me that the reason he didn't file anything from September to February 10th was he was waiting for discovery. That's what he told me. I thought he was lying. But no, now that I'm doing it myself, I see that he's right. And if you look, I got right here, Rule 16, it says right here, discovery. They should have been giving it to me. It hasn't been 10 days, it hasn't been 10 weeks, it's been over 10 months. He's given me no discovery. Like I say, and now Ms. Friends seems like she doesn't feel like she has to help. But my point is this, Your Honor. I also want to bring up ineffective counsel. Let's see, what else? Oh, the bad ruling. Last time you asked me if I could comment on the ruling. Only I hadn't seen what you had ruled. It took me 2 weeks before I ever got a paper of what you were saying. So I'd like to comment on that now, which is, yeah, it's a horrible ruling. Act 178
So,
was
Mr.
designed
Ruggles, this is not the time to
All right, fine,
discuss
Your
it. I wanted to ask you about position regarding representation, because that's what's pending right now. So is it your desire to have counsel represent you for everything?
No,
or?
I just want help with writing subpoenas and motions and all the little things that I don't know anything about. And I thought that she was being paid to do that. She didn't have any trouble doing it when Mr. Damerville was asking her, but now suddenly there's a problem when I'm sick.
Okay, so you want to continue to represent yourself?
Yes, with assistance, because I'm sick, I'm dying. I've lost 4 teeth, I got kidney failure, and I want to get this over with before I go.
Judge, if I could have a minute, please.
Okay.
Yeah, me too. I still want to be pro se, but I'm hoping for assistance. If I can't have any assistance, then I'll just be pro se. I'll do it myself, that's fine.
Okay. So you want to continue to represent yourself?
Yes,
Sure.
sir.
Okay.
But I was hoping to at least have some help.
And you're
I'm trying to get counsel. I'm working on some pro bono counsel, people from out of town, right now they're out of country. But until then, I need help. I'm sick, I can't do it no more.
And, okay, so, Ms. Friends, do you have anything else to say today, or?
There's the only thing I would add in response, just for clarification, in the event that the court was looking for some clarification based on the statements made by Mr. Ruggles this morning. I believe the only thing short of the motion to withdraw that I filed has been a stipulation to extend a deadline. I haven't filed any other separate motions as
2
Mr.
weeks late.
Ruggles. I believe there are two separate stipulations that needed to be filed to afford Mr. Ruggles some additional time from the first stipulation to extend. I then had to do a second one. Short of that, the only request I have, attempted to provide samples to Mr. Ruggles to help him comply with the rules. There has been some disagreement as to what advisory council's position and or assistance level is going to be required of advisory council. We have a disagreement there. Mr. Ruggles, as indicated in my motion to withdraw, believes that there's colluding with the state. I don't think that at this point the advisory council and defendant can continue to work together. So I am asking the court to grant my motion to withdraw. It was my understanding that Mr. Ruggles was seeking court-appointed counsel to assist him, not advisory counsel, but actual court-appointed counsel, which is what I was trying to clarify with him this morning. If that's not the position he's taking, then the court can strike that from my motion. I was trying to assist him in getting court-appointed counsel. As to the motion to reconsider his previous waiver of right to counsel, because it is filed motion to withdraw as advisory counsel and to reconsider his waiver of right to counsel. But if he's not seeking that at this time, that's fine, Judge, but I am seeking to withdraw as advisory.
Okay. So, Mr. Ruggles, you're suggesting that you prefer to have other, at least standby counsel, not pending your ability to get pro
I'd like
bono
to get
counsel?
some help writing these motions while I'm trying to get these other guys to come on board. I'm certainly not wanting to give up any right to a speedy. I'm hoping to have this go off in either late October or early November. That's what the guy that's out of the country's saying, that he can do it pro bono, says that's when he'll be available. He's a very expensive lawyer. He says he'd be willing to help me for free because he feels like I'm getting railroaded, and I feel the exact same way, Your Honor.
So, I could try to find another standby counsel for you, but I'm not sure that would satisfy, whoever it is would satisfy your concerns, but we can try to do that.
If you think you can find somebody that will actually help, somebody who's not doing the will of Mr. Damerville.
Well, see, that's the thing. It's going to be based, probably, the evaluation will be based upon your subjective determination as to whether or not you're getting help. So, it cannot be just to your satisfaction, you know what I mean?
Well, I understand.
Yeah.
It's not for satisfaction. All I want is help in these subpoenas and this hearing that's coming up. And can anyone explain to me why Mr. Damerville still hasn't given me my patient records? 14 people. That's the medicine that they confiscated. He knows it. It's been over 10 months. He's had 10 days, Your Honor. I'm just wondering why.
So, I mean, one way of, if you feel that you haven't gotten discovery, then there's a motion to compel.
He's holding me to the letter of the law, but I feel like the court is not holding him to the letter of the law. It says 10 days. He said I was supposed to compel. I looked that up. Compel is only for civil cases, not criminal. You don't have to compel in a criminal case.
Judge,
And why did Mr. Haspy do it 110 months ago?
Judge, not to complicate matters any, but if at all possible, since this is going outside of the motion, if we could maybe address my motion. If the court's inclined to grant it, then I can depart the proceedings and.
Yeah, well, the motion is, whatever the motion is.
I'm facing 3 lives, Your Honor. I've had 10 minutes to talk about my defense. That's all I've been given, 10 minutes. And now I have 2 hours in the future, but yet Mr. Dannerfield refuses to give me the discovery, and Ms. Franz refuses to help me write subpoenas. So I'm just saying, I feel like I'm really getting the tail end of this.
Okay. So,
I mean, a lot earlier when I asked you,
so,
can you tell me how?
Mr. Ruggles, you might not.
I'm sorry, Your Honor.
You want to speak with Mr. Ruggles, or are we done? Because we, okay. All right. So, the court will grant the motion to allow Ms. Friends to withdraw. The court will try to find substitute counsel, standby counsel for Mr. Ruggles. Do we have another hearing pending? Maybe we should have Mr. Ruggles come back in 3 or 4 weeks.
We have a hearing on August 26th, is the hearing on the,
Yeah, but we should have counsel hopefully before then. So schedule a hearing before August 26th so that we can have standby counsel hopefully appointed before that time.
Wednesday, August 24th, 2016 at 8 a.m.
August 24th.
Right. So, Mr. Ruggles, you ordered to return to court on August 24th, 2016 at 8 in the morning. So
Yes, Your Honor.
hopefully we can have counsel appointed for you at that time.
2 days before the hearing.
Okay, and Ms. Friends, you are free to go if you wish.
Thank you, Honor.
You gonna draft the order?
I'll prepare the order, Judge.
Yes, thank you. So you wanted to respond to whatever Mr. Ruggles had been concerned about, Mr.
Yeah, Judge, I would. First of all, he's gotten a ton of discovery from us. He just hasn't gotten the discovery that he wants. And I've had many emails with him. We went out and viewed the evidence. He's asked for copies of the records that we took from him. We have copied them. That was completed on Thursday. The secretary's out on Friday. He got the opportunity to review those records, which are physical evidence. He went down and looked. He wanted them copied. We've copied them. The problem is that between the time that we did that and today, the State Supreme Court issued an opinion, and there was a certified question from the U.S. District Court regarding medical records of third persons, and because of that opinion, I told Mr. Ruggles that I was having my secretary separate out anything that might be considered the medical records of a third person. She's done that, and then I told him I would file a motion at that time for instruction with respect to those records. And that's exactly what I intend to do, is file a motion for instruction. If the court says he's entitled to them, that's fine. I'm not trying to hold anything about those records. Now, on the other hand, I didn't realize that he was suffering from, and I've known Mr. Ruggles for a long time. I wasn't aware that he's suffering from the serious medical conditions that he has. And with that being said, you know, I hope we can still work together. I answer his emails. The latest one, he requested of me, which he believes that I have to turn over in 10 days, is he apparently became aware that one of our officers was an immigrant from some other country, and he asked me to go out and find out any other immigrants, and then to seek out any other criminal histories that they may have in these other countries. And I'm sorry, you know, he's gonna need a lawyer who knows how to do letters rogatory in the court, granted, but that's not the type of fishing expedition that I'm gonna go on. So, but other than that, we've had exchanges. I've been keeping him up to date on discovery that I am not required to turn over in 10 days. I don't under the rules, there's no requirement that I copy physical evidence. There's only a requirement that I give him access to, but I've copied it anyway.
Okay, so Mr. Ruggles, your primary concern, for did I understand, is these,
The patient record, Your
right,
Honor.
okay. And so Mr. Darmaville has suggested that this is what he's going to do. What I can do is just give him a hearing date so we can progress. You have a time
Your Honor,
certain.
I believe the kid that was helping me sent you a copy of the emails, but Damerville went further than that. Damerville at one point threatened to have every patient come in and okay that he could give me the information. I'm pretty sure you got a copy of the email, Your Honor.
Okay, okay, so let me just schedule a hearing. You file your motion so that in a timely manner so that we can have it here, okay?
Okay.
So, it's gotta be the week of August 15th. I'll be gone, so that's why I'll be gone for a couple of weeks.
Wednesday, August 17, 2016 at 9:30 a.m.
Just for calendaring, Judge, I would be titling that as a motion for instructions.
Okay.
And is this in addition to the August 24th hearing?
Yes. So what we could do is push up the time for the August 24th hearing to August 17th. So try to get counsel for you at that time.
Okay, thank you.
Okay. So one hearing. So I guess I should say, Mr. Ruggles, you ordered to come back to court on August 17, 2016 at 8 o'clock in the morning, and court will vacate the August 24th hearing, I think it was.
Yes, August
Okay.
24th, yeah.
Okay.
Okay, but I gotta be August 17th first, right?
Okay. Thank you.
Thank you, Your Honor.
Thank you, Judge.
All right, aloha everybody. Update from the Alternative Pain Management Collective. Just went to court. Got rid of my Cody friends, who was my advisor. Apparently she felt like she didn't have to help. So we curbed her. The judge is looking for a new lawyer. Hopefully someone that'll be helpful. In the meantime, my teeth are falling out. My kidneys are going. So we're hoping to get this on in a timely fashion so that we can fix this for everybody. Hey, I love the Big Island and everybody out there. Aloha.